Hi, my name is Douglas Frazer. I'm an attorney with DeWitt Ross Stevens in the Metro Milwaukee office. I'm going to spend a few minutes speaking about a lawyer's guide to IRS audits of lawyers. There are three main points to keep in mind if your law firm or your law practice is selected for an IRS audit. The first is to think ahead about the process. What do I mean by that? That means keep good records. Keep and maintain good records. Because chances are at some point along the time you are going to be subject to an audit by one of the tax authorities, meaning the IRS or the Wisconsin Department of Revenue. Keep bank statements. Keep receipts. Keep invoices. Keep all your client billing records. Now, you don't have to keep paper copies of these documents anymore. You can keep them in electronic form, but just know where they are and have a system in place where these records are recorded and maintained and stored so you can retrieve them in an efficient kind of way. The second point about records is this. A frequent issue with regard to these kind of audits are travel and entertainment expenses. And also mileage. Keep records concerning those. Let's deal with mileage first. The best practice is to keep a mileage log. Okay, keep that in your car, write down where you're going, how many miles, the date, what the purpose was. That's the best evidence. But it's not the only evidence. If you can't come up with that, come up with a calendar and recreate it in that way. Come up with other documents that show where you might have been, and then you can retrace it. Don't be put off if the auditor says it's not acceptable. The auditor is not a lawyer, and what is the best evidence as we know, not always the only evidence. The second point to consider in an examination by the IRS or the Wisconsin Department of Revenue is that the examiner is not a lawyer. This touches on an area that I covered previously. The best evidence isn't the only evidence. Often examiners will have a document in mind that they want to see with regard to substantiation of certain records, and you may not be able to come up with it, like a mileage log or a particular receipt or a particular statement. But that doesn't mean there are not other forms of evidence you can use, including oral testimony. Lawyers know, because we've taken courses in evidence, that there are lots of different kinds of evidence. There are documents, there's testimony, and documents and testimony aren't always self-explanatory. That's why finders of fact weigh evidence and test credibility. Well, all this is second nature to us, but it may not be to the examiner, which leads to the third point, and that is there are avenues for appeal. If you're not satisfied with the results or the expected results on the examination level, consider going up the ladder. One of the reasons is because the examiner doesn't have an appreciation of litigation hazard or is unreasonable concerning what reasonable substantiation of records might mean. Another is just a disagreement about the interpretation of the law. Regardless, sometimes it is most effective and efficient to cut things off at the examination level in a professional and nice way and just take it up on appeal. Those appeals can consist of talking to the manager. It can consist of going to the administrative appeals level of the IRS or the Wisconsin Department of Revenue, or in a narrow range of cases may even consist of filing suit. This doesn't mean you're going to trial if you're subject to an IRS examination. It just simply means you're going to another higher level to discuss settlement with the prospect of trial if you can't settle. Remember, as a general rule, the higher up you go, the more sophisticated an individual you'll deal with. An individual who will have a more refined, a better appreciation of litigation hazard, and who may be able to settle a case with you on terms that are much better than you would have received at a level below. For fuller treatment of these issues and an expanded and amplified form, I might direct you to my article that appeared in the Wisconsin Lawyer in April of 2012 called A Lawyer's Guide to IRS Audits of Lawyers.